And we now take you live to Vigyan Bhavan in New Delhi, where Prime Minister Narendra Modi has arrived. He will be delivering the valedictory address of the first ever global conference to strengthen
Niti Aayog, Mr.
arbitration and enforcement in India.
Welcoming the Prime Minister here in the plenary hall. Everyone anxiously await the arrival of the Honorable Prime Minister. Under the leadership of Honorable Prime Minister, as India attracts a lot of foreign direct investment and is a bright spot in the world economy, how does India position itself as a hub for arbitration, for expeditiously disposing of the disputes, is what is the focus of this global conference.
Minister of India. May I request the CEO of Niti Aayog, Mr. Amitabh Kant, to please welcome all our guests, speakers and delegates.
Honorable Prime Minister of India, Honorable Chief Justice of India, Honorable Law Minister of India, Honorable Chief Justices of Singapore, Bangladesh, Bhutan and Maldives, Honorable Justice Dave, our distinguished Attorney General, our Minister, Mr. Inderjeet Singh, the Vice Chairman, Mr. Panagaria. A very good morning to all of you and a very warm welcome to all the participants of this conference. This is the valedictory session of the Global Conference on the National Initiative towards Strengthening Arbitration and Enforcement in India, organized by Government of India, the Indian Judiciary, and several partners. This is a unique initiative in many ways. Firstly, this is the first time that government, judiciary, Niti Aayog, lawyers, foreign institutions like the International Court of Arbitration, the Permanent Court of Arbitration in Hague, HKIAC from Hong Kong, the Kuala Lumpur Center for Arbitration, LCIA from London, SIAC from Singapore, and the Indian institutions of CII, FICCI, ASSOCHAM, PhD have all come together to prepare the roadmap for making India the center for arbitration. I have attended several conferences in Vigyan Bhavan, but during the last 3 days, we've seen huge interest, energy, vibrancy, and dynamism. Everyone here wants Indians to arbitrate in India and to provide speed and efficiency and cost effectiveness and make India the center for arbitration. Thirdly, I have never seen distinguished Supreme Court judges like Justice Kehar and Justice Sikri sitting here the whole day yesterday from 9:30 a.m. to 6:30 in the evening and taking detailed notes. This shows their immense desire and interest in providing impetus to arbitration in India. Honorable Prime Minister, sir, your government has taken a series of structural reforms to make India a highly efficient economy. From bankruptcy law, National Company Law Tribunal, to focus on ease of doing business, to creating a sense of competition among states, to GST, to a new arbitration law. These are all reforms of huge magnitude. We are now the #1 recipient of foreign direct investment across the world. And as you have said, sir, we are one of the most open economies of the world today. This has enabled India to be the fastest growing large economy in the world and remain an oasis of growth in the midst of a very, very barren economic landscape outside India. But we need to grow at rapid rates for next 3 decades to be able to lift a very young population above the poverty line. For this to happen, we need to create the ecosystem for becoming the easiest, the simplest, the speediest destination for enforcement of contracts, for settlement of commercial disputes, and focus on becoming a center for Indian and global arbitrations. I take this opportunity to welcome the Honorable Prime Minister, whose passion, commitment and zeal for predictability, consistency and clarity of policy issues and for making India easy and simple is well known. He is a great believer in radical reforms and in making India a key center for arbitration. On behalf of the organizing committee, I welcome you, sir. I take this opportunity to welcome the Honorable Chief Justice of India, who has been the patron-in-chief and has taken an immense amount of interest in driving this conference to great perfection. He has been the guiding force in many ways. Thank you very much, sir, for inspiring us in this conference. I take this opportunity to welcome our distinguished Law Minister, whose ministry has been a very, very active participant in this conference. We thank you, sir, for joining us on this special occasion. I also take this opportunity to welcome the distinguished Chief Justices of Singapore, Bangladesh, Bhutan, Maldives, for giving us their perspective on the future of arbitration and sharing their experiences in the morning today. It was a wonderful session chaired by Justice Kehar. I also welcome the Honorable Minister, Mr. Inderjeet Singh, and our Vice Chairman, Mr. Arvind Panagaria. On behalf of the Organizing Committee, I welcome Honorable Justice Anil Dave, Judge of the Supreme Court of India and Executive Chairman NALSA, and the distinguished Attorney General, Mr. Mukul Rohatgi. And finally, I welcome Mr. Justice Manmohan, who has played a very critical and significant role. He's been a great partner in this entire organization. Many years back, I have worked for a long time with his father, and he's inherited all the great qualities of his father, Mr. Jagmohan. So it was a wonderful partnership between the government and the judiciary. Thank you very much, sir.
May I now request the Attorney General of India, Mr. Mukul Rohatgi, to please address the conference.
Honorable Prime Minister of India, Honorable Chief Justice of India, dignitaries on the dais, ministers, Chairman Niti Aayog, Mr. Kant, sitting and retired judges of the Supreme Court, sitting and retired judges of the High Courts, Chief Justices of foreign jurisdictions who are present here, senior and junior lawyers, students, other dignitaries in the audience, and friends. It is a proud privilege for me to be here at the valedictory address. I attended the morning session, though in part, and I found a very vibrant exchange of ideas moderated by Justice Kehar. Unfortunately, there was not enough time, so the session had to end at 11. But it was very interesting to see and hear about things like emergency arbitrations, which are unknown in this country. But I must first tell you the origin of dispute resolutions of ancient India. It started in the Vedic period, thousands of years ago. India was essentially an agrarian society. People lived in villages. There were no metropolitan cities. Simplistic settlement of disputes was through panchayats. It consisted of 5 mature elders in the village. Their decision was accepted by the disputants. It was transparent and open to the public. They were equal in status to that of Parmeshwar, the god of justice. Hence the phrase Panch Parmeshwar. One is reminded of a story of Munshi Premchand called Panch Parmeshwar, which we all read in school. Premchand was one of the best writers of short stories of Hindi. Panchayats continued even through the Mughal reign. The Mughal emperors allowed resolution of disputes even though there was a legal system. There were several appeals, including an appeal from a panchayat. The final court was headed by the emperor, who used to exercise appellate and original jurisdiction. Interestingly, even inter-village disputes used to be settled by a panchayat consisting of members of both the villages. Advent of the Industrial Revolution brought formal arbitration to UK and USA and then to India. The English Act came in 1899 and the Code of Civil Procedure 1908 had a chapter on arbitration. The 1940 Act was the first act to recognize the advent and importance of alternate dispute resolution. This act provided for a frequent intervention of the law courts, which led to substantial delays. The 1996 Act came as much needed relief. It was based on the UNCITRAL model, in sync with other world models. However, some provisions were ambiguous, led to several disputes which were settled by the Supreme Court. The Indian economy opened up in 1993 and international commercial arbitrations therefore came about, but enforceability was, however, an issue. The 2015 amendments are wholesome and welcome. They put a focus on costs, affordability and expedition, which has been sorely lacking. To succeed, an arbitration must be cheap, fast, friendly and informal. It is said that the 21st century belongs to Asia. Under the dynamic leadership of the Prime Minister, ably assisted by our Finance Minister, India has now become a dynamic powerhouse. The Indian economy is expected to grow at the rate of 7.5% this year. This is one of the highest rates of growth compared to the Western world, where the growth is sluggish and many parts of the world are facing internal and external conflicts. This growth means a large amount of FDI in the country. Foreign investment will also bring disputes which will be of an international character. To reassure foreign investors of the security of their investment and exit if necessary, it is necessary to bring about speedy resolution of disputes. A great fillip has been done by the government in the shape of 2015 amendments. It is also necessary for the judiciary to lend a helping hand, and if I may say so, a supporting one. A healthy relationship between the traditional judiciary and the arbitration forums will provide the right directions. We have large number of associations in different parts of the world, SIAC, LCIA, Hong Kong, KL. We can also make India a hub of arbitrations so that the litigation can be done domestically in India and not spend exorbitant amounts of money. A center could be in the shape of the ICADR center at Basant Kunj, which is housed on a big plot with several floors at its command. I wish to take a minute on the criticism which has been levelled on the amendment, principally saying that the time of 1 year is too short. In my respectful submission, 1 year is not short. If you remember the 1940 Act, it provided for 4 months, but nobody ever adhered to 4 months. For the first time, we have a limit of 1 year, extendable by 6 months, and thereafter extendable in rare cases by the court. So, if 1 year is a timeline, and I must remind you that the timeline of 1 year has been set by the Supreme Court in a 2014 judgment dealing with criminal cases of elected representatives, where the court said that 1 year should be the outside limit of concluding a criminal trial. If that can be done in 1 year, then certainly I think 1 year is appropriate. And I don't think we should start with a criticism right in the beginning. We should look at it let it run for a while, and if there are some problems, they can be ironed out. May I remind you that the Nuremberg War Crimes Tribunal in Germany took less than a year to complete all the war crimes, from November to October 1946. Our commercial courts in the Act also have similar tight timelines. So why should we not give it a start? I am informed that the Palkhiwala Center of Arbitration in Chennai has a timeline of 10 months, extendable by 2 months. And Mr. Datta told me that all the arbitrations done by that center were completed within the timeline. If that can be so, then certainly 1 year is not too short a period. I must also tell you that in Gujarat, there is a project called Gujarat International Finance Tech City, in short GIFT. That is a project like in SEZ to encourage foreign investment. And their SIAC, the Singapore body, has been asked to set up, and they have established a system for speedy arbitration. Incidentally, Indians are the highest consumers of the Singapore Center in terms of arbitrations. If that is so, then I don't see why we cannot come here and do it here. I must add lastly, and I say with due respect, because I have many retired judges of high distinction sitting before me. My experience has shown that the arbitrations in India are really conducted as a replica of the court. If you have a replica of the court systems, then no arbitration can be done expeditiously. You have to forget, the retired judge must forget that he is not sitting in a court now. He is sitting in an arbitration. So you can't have the same formal procedures. It equally applies to lawyers. Lawyers want arbitrations as part-time. So you do 10 to 4 in court, 4 to 6 in arbitration. That can't work. You must have an international an arbitration bar where the lawyers must be belonging only to arbitration, starting an arbitration at 10 a.m. That's the only way that we can shake off this sluggishness. And lastly, I would like to make a short submission. Arbitration obviously is best suited for a country of this nature where the court's dockets are bursting. I am not going into reasons of the bursting of court dockets. But I find that when arbitration matters are taken up, they are treated like any other matter. In some jurisdictions, objections to an arbitration award are registered as a suit. So if you look at it like a suit or an appeal, then obviously it will go the same way as a normal time of an appeal. They must be separated, there must be sensitization, and that's the only way that we can have a smooth disposal of a challenge to arbitration and an appeal therefrom. Supreme Court has said on many occasions that there should be least interference. But what will happen? An award of 3 retired judges goes to a civil judge in a jurisdiction where it is challenged. It is tried as a suit. Obviously, it's going to take a number of years. That mindset also must change. It must be a part of judicial training of the lowest to the highest levels, and that's the only way I think we can achieve something in this sphere. That's all I wish to say. Thank you very much.
May I now invite the Honourable Mr. Justice Anil Dave, Judge of the Supreme Court of India and Executive Chairman, NALSA, to please address the gathering.
Very good morning to everybody. Since yesterday, I have been hearing about the delay in arbitration proceedings and Section 29A. So I have become so conscious, I am so much worried that I have to finish my job within 5 minutes which has been given to me. I will try to see that I don't delay the proceedings here also. And I wish that we all do the same thing in arbitral proceedings also. Dignitaries on the dais. my brother and sister judges, including former judges and judges who have come from foreign country, ladies and gentlemen. First of all, let me congratulate the organizers. A wonderful job has been done by the organizers. The conference was superb. It was very fruitful. The discussion was excellent. Yesterday when I was here, I saw that the discussion was really fruitful. Really we have learned something. At least I have learned something that I have to finish it within 5 minutes. Our country is now progressing. Our foreign policies are improving. We are doing very well in all fields. We have started manufacturing so many things. Make in India, that is our goal. Why not to give justice also here? We don't make justice, but at least we give justice. Why go elsewhere? Why not to have good system of justice here? Very often, I have seen that Indians enter into an agreement of arbitration, wherein an Indian is appointed as an arbitrator, but the place of arbitration is elsewhere. The cause of action is arising here in the country. Why do that? I think we have got excellent judges, we have got excellent arbitrators, we have got excellent lawyers. But the entire difficulty is with regard to the procedure, the delay. And 2015 amendment has done a great job. I am very sure that the period which has been granted by section 29A, the upper limit, is not less. In a given case, you may ask for some more time, but if you can really become short, and I am very sure that if the arbitrators and lawyers, if they cooperate, it is possible. It can be done. I may tell you one thing. For the purpose of getting justice, you can either go to a civil court or you can go to an arbitrator. It is a known fact that going to civil court is a little bit more economical. You pay something more to the arbitrator, you pay something more to the advocates, counsel appearing before the arbitrator. With wide open eyes, litigants decide to go for arbitration. They know that they are paying more. Is it not a moral duty of the lawyer appearing before the arbitrator and the arbitrator to see that the litigant who has spent more must be satisfied? He must be given back, he must get a satisfaction that his dispute has come to an end at an early date. No businessman ever likes to have a dispute. He would never like to have a problem. He would like to do his business smoothly. But unfortunately, very often problems do arise. And they have to go to court or to an arbitrator. Once they decide to go to an arbitrator, I think it is a moral duty, moral obligation of the lawyers and the arbitrators to do their job quickly. If we understand this moral obligation, I think section 29A is not required, because the principle of morality are followed more in our country rather than legal principles. I am very sure that we all will do that. We will see that our country prospers. We do the job here in our country. Not only that, we bring other persons here to do that arbitration work. As we are exporting so many things, people purchase things from us. Why should they not come for justice here, especially when it has been said that that is our tradition. We do justice, our panchayat also does justice, our layman also knows what justice is. Then I'm sure that we'll have a grand success in this field. I wish all the best. Jai Hind.
May I now request the Honourable Union Minister for Law and Justice and IT, Government of India, Mr. Ravi Shankar Prasad, to please address the conference.
Shraddheya Pradhan Mantri Ji, Honorable the Chief Justice of India, Justice Dave, my distinguished colleague in the Council of Ministers, Ravindra Singh, Shri Arvind Panagaria, Justice Manmohan, Amitabh Kant, distinguished Chief Justices from the foreign jurisdiction, Honorable Judges of Supreme Court of India, former judges, ladies and gentlemen, and my young friends sitting there. First of all, let me compliment Niti Aayog for organizing this very extraordinary conclave, how to make arbitration enforcement more appropriate for India. I've been told that the exchange has been quite meaningful. We heard Justice Dave saying about that, and surely a roadmap would emerge. Under the dynamic and inspiring leadership of our Prime Minister, India is speedily emerging as a land of hope and promise, not only in the field of investment, economy, trade or commerce, but India today is being viewed as an emerging global superpower, propelled by the extraordinary strength of the human resource of its 1.25 billion people. Certain path-breaking programs have been taken, like Digital India, Make in India, Skill India, Startup India, Smart Cities, all designed to make India a knowledge-driven society, more for inclusion and empowerment of the people of India. That being the scenario, surely India emerging as a global hub of arbitration has increasingly come into focus. And I see primarily three focus areas where we need to work together. I'm sure you must have talked about it. The first is encouraging the growth of institutional arbitration. The second is the role of the government as a facilitator to enable that to happen. And the third is finding a right balance for judiciary to uphold the public policy and respecting the comparative autonomy of the arbitral proceedings. These three are the fundamental issues which we need to seriously reflect upon. The Law Commission in the 246 report has very categorically stated that we need to encourage institutional arbitration. The time has come. Institutional arbitration with its own proceeding leads to a better follow-up of timeline, good quality of arbitrators, and above all, we have to ensure the integrity of the arbitrators. If we have to really ensure a fast-track system. I'm happy that good institutional arbitrations are emerging in India. This beginning has been made. Now, on behalf of the Government of India, let me assure that this shall remain a very priority area for the government. As regards the role of the government as a facilitator is concerned, we have taken a lot of policy initiatives to ensure ease of doing business and also to make India a big hub of investment. We have come with commercial court, the bankruptcy code, the other legal initiatives which Amitabh Khan talked about, the GST, one country, one tax, has become a reality under the foresight and leadership of our Prime Minister. Debt Recovery Tribunal Act amendment, all are designed to fast-track. And in the Arbitration Act, as the Attorney General pointed out, we have consciously shortened the disposal rate, incentivizing quicker disposal, penalizing delayed disposal. That has been the essence. On the legal front, we have done our best, and if something is more required to be done, we are willing to walk the extra mile. As regards the judicial intervention is concerned, surely, as the Law Commission in the 246 report very incisively commented, it may not be possible to completely oust judicial jurisdiction. We are very proud of our Indian judiciary. But how can we accord a balance between judicial intervention and judicial restraint? And I think this particular conclave of the last 3 days must have ensured a serious reflection upon those concerns which go to the root of the matter. Let me also share some of my concerns in the wake of international arbitration. And what are my concerns? Some of these I had occasion to reflect when I was addressing the BRICS International Arbitration Conclave. How is it that so many countries of the world today are revisiting their arbiter adjudicatory process? Are they realizing that something is going wrong? South Africa walked out in many ways of the bilateral treaty obligations and went for a legislative route. Brazil went to the ombudsman way, completely ignoring or taking a different view as far as international arbitration issues are concerned. Indonesia, other countries are also revisiting.
Is the international arbitration ecosystem presently is too ad hoc? If I hear certain apprehensions, and let me be very honest today, ladies and gentlemen, if there is structural bias, we are very proud of our judiciary, fine judges of India, fine lawyers of India. India is an emerging economy, a good part of the world. But how many arbitrators of Indian origin or Asian origin we see or international arbitration ecosystem? We all have respect for Queen Counsel barristers, but why is it that they are treated as the only embodiment of arbiter knowledge, hopping from one arbitration to other? These are issues which will have to be reflected upon. And yes, the international arbitration ecosystem need to recognize that today the world is changing, Asia is emerging, India is emerging, many other countries across the board are emerging, and they need to find a voice in the entire international arbitration ecosystem. The other issue I would like to highlight as a matter of my concern is, ladies and gentlemen, is a recognition of the domestic laws and finding a proper balance between safeguarding the investor's right, which ought to be done. We must fast-track his concerns, but there has to be a balance between the investor's right and the sovereign right of the government and the right to regulate. I think that remains an area of serious concern. Recently, I had the occasion to examine a case of India where we have suffered an adverse order. We could do some proactive initiative in pursuit of essential security interest. Now, what the international arbitration did was to segregate 60% is essential security interest, 40% is not. I don't think essential security interests can be bartered or compartmentalized. Either it is essential security interest or it is not. I think all these assumptions arise because of an increasing problem which I am witnessing, both earlier as a lawyer and now advocating law ministry, that local laws are not being appreciated worldwide, and local laws have an issue which needs to be respected. With these concerns, let me conclude our commitment to make India a big hub of international arbitration. And as the Prime Minister has always said, make in India, skill India, digital India. It is time to come to give a new slogan, resolve in India, which we are going to work with great commitment. Thanks a lot. Namaskar. Jai Hind.
May I now invite the Chief Justice of India, Honorable Mr. Justice T.S. Thakur, to please give the presidential address.
Honorable the Prime Minister, Honorable Minister for Law, Justice and Information Technology, Shri Panagriya, Vice Chairman of the Niti Aayog, Minister of State for Planning, Shri Rao, my esteemed brothers, Justices A.R. Dave and Justice Manmohan, Shri Mukul Rohtgi, Attorney General for India, Shri Amitabh Kant, Chief Executive Officer of Niti Aayog, Chief Justices from different countries, Judges of the Supreme Court present and former, Judges of the High Courts from within and outside India, distinguished lawyers and arbitrators, representatives of different arbitration centers from within and outside the country, judges from the district judiciary, distinguished invitees, students, ladies and gentlemen. I am delighted to be among you this morning in this valedictory function, which marks the conclusion of a 3-day conference on a subject of great contemporary importance. This conference, as we all know, has attracted participation from Chief Justices from different countries, judges of the Supreme Court and High Courts, present and former, outstanding jurists, outstanding lawyers, arbitrators, representations from arbitration centers from different countries. It has also attracted participation in a large number from industries and commerce. Representatives have come from that sector also. And of course, judicial officers from the district judiciary, lawyers and students all. The feedback that I got after yesterday's deliberations here was that never before has there been a conference on arbitration law so well attended as this. I myself realize that to have such outstanding and distinguished pool of talent from all over the country and from abroad is something very unique. And it symbolizes, in my view, the importance of the subject which was slated for discussion. I joined the Law Minister for complimenting Niti Aayog, but I also take this opportunity to compliment the National Legal Service Authority, the Ministry of Law and Justice, ICADR, Department of Industries, Policy and Promotion, National Institute of Labour, Employment, Research and Development, for assembling such a great pool of talent and distinguished speakers and participants for this conference. Mediation, conciliation and arbitration have dimensions not only for international dispute resolution but also for domestic adjudication. For domestic adjudication of disputes, it has a great promise, not only for the litigants who resort to such process, but also for overworked courts and judges. We know that in this country, as has been rightly pointed out now by the learned Attorney General, courts from the apex court, right from the Supreme Court down to the municipal courts, are overburdened. Judges are overworked. You can imagine the kind of burden that judges share when you think that 18,000 judges handle nearly 50 million cases every year in this country, out of which 20 million cases are disposed of. The ever-increasing flow of cases to the courts, or the avalanche of cases that descends on the courts, is constantly putting the judicial system under great stress. And therefore, when we look at the domestic situation, we look for some alternatives to the conventional methods of adjudication of disputes. The conventional methods, as has been pointed out earlier by the speakers who preceded me, are arbitration, mediation and conciliation. In fact, the Attorney General referred to you that arbitration and mediation have been steeped in history, and I would go back, I would say they are steeped even in mythology. For all of us know that in Mahabharata, when the Pandavas and the Kauravas did not arrive at an amicable settlement, Lord Krishna went as a mediator. He told them, all right, give them 2 or 2.5 or 5 villages. So mediation has been there since times immemorial. Of course, it has its own lessons, that even God can fail in his attempt to mediate, and the Lord Krishna failed in the attempt to mediate. But that doesn't mean that mediation is unsuccessful or dispensable. I think that should be perhaps the first stage in the process of adjudication, whether by a court or by way of arbitration. It is also a lesson for the parties who do not see reason. Those who did not see reason in the suggestion made by the Lord had to be eliminated. They were decimated in the battle that followed. So, mediation, arbitration and conciliation are steeped in our ethos, and therefore they are not new to us. The only thing is that we need to redefine our role in the modern context and make use of these processes which have been always found to be very useful. The arbitration method of resolution of disputes is speedy, inexpensive, has some advantages because the parties themselves choose their judges, and therefore ought to be encouraged, not only qua international disputes but the domestic disputes also. But let us talk about the international dimension of the importance of arbitration. And that dimension is no less important. We all know that from a mere 2.5 lakh crores, 270,000 crores at the time of independence, the economy has grown to 57 lakh crores by now. We know that the foreign exchange reserves of the country have gone up from $2 billion to 300 billion US dollars. We know that as on 30th June 2014, there are in this country 3,245 foreign companies who have established shop and who are working, engaged in different activities. As on that day, 1,476 foreign companies were working in Delhi alone, followed by 772 such companies in the state of Maharashtra. The Department of Industrial Policy and Promotion has disclosed that in 2015-16, India received a foreign direct investment of 40 billion US dollars as against 30 billion US dollars in 2014 and 15. The increase was 29% over the previous year's investments. We are therefore, according to studies and those who are experts in the field of economy, poised to take over or overtake China and US in terms of economic growth by 2050. Something that each one of you and each Indian in this country should be proud of. And yet, we remain very low in terms of our rating in the ease to do business. We were told by the distinguished speaker yesterday in the evening that out of 189, India ranks around 130 in terms of ease of doing business is concerned. And one of the concerns which any foreign investor has regarding the security or the safety of his investment is the efficacy of the judicial system of the country where he is proposing to invest. If the judicial system is sound, he is tempted to invest because security of his investment is the primary concern he is worried about. And therefore, the need for strengthening the judicial system is so intimately and deeply connected with our ambition of attracting more and more direct investment from other countries. There are, in that context, challenges which we must remember and confront. The first is, we must have credible institutions that offer arbitral services. Yesterday you heard His Excellency the President of India identify three main players or three main stakeholders in this process. The first is the institution. You ought to have institutions here in this country. I believe in China there are more than 300 institutions that offer arbitral services. In India we have just about one, that too promoted by the Government of India, and now with the association of the Supreme Court of India, it is struggling to find its feet. The ICADR was established some 20 years back at a huge investment made by the Government of India. That institution handled over a period of 20 years just about 20 cases, which is a very, very dismal performance, if I may say, with great respect to those who were handling the affairs of that institute. But then, apart from ICADR, there are a handful of them, a few other institutions, maybe in private sector. One of them has recently come up in Bombay, and one or two other institutions. The result is that arbitrations today are being conducted by the arbitrators and by the litigant public in five-star hotels, sometimes in some clubs, like in Niti Bagh Club, I believe. Niti Bagh Club has become a very popular place for doing arbitrations because there are no institutions outside Niti Bagh Club which can possibly house such events and provide facilities. So the first requirement that I think we ought to address, that we need to comply with, is to establish credible institutions that would offer proper services related to arbitration. The second is, it is not just a handful of Supreme Court judges or some High Court judges who can meet the challenge of such large number of matters that are likely to go to arbitration or can go to arbitration, ought to go to arbitration. We need to train arbitrators, and these arbitrators need not necessarily be only from judiciary, because domain experts also play a very, very significant role in contributing to the disposal of cases and in deciding issues that are of complicated technical nature. We also need to look into the legal framework for speedy and affordable adjudication. If you ask me why is Singapore today so popular with arbitrations, why is Singapore a preferred destination for arbitration? It is not because Singapore Arbitration Center has a very beautiful building, or it has some transcript, some translation facilities that we can't acquire. It is because of the legal framework which that country has in terms of how the judiciary will deal with arbitral awards that makes Singapore a preferred destination. I think we need to revisit our legal framework, because what really ails and what really afflicts the Indian arbitral scene is not the time that the arbitrators take in deciding the cases, but the time which the courts, after the arbitrators have delivered the award, take to decide challenges to the arbitral awards. You may make a provision, as you have done in Section 29A, that an arbitral award must be made within 1 year. An arbitral award can come within 1 year. May require some time, some extension. There has been a very heated debate here. There have been divergent opinions expressed on that regard, that whether we should fix a time limit. But let us assume an arbitral award is made possible within a period of 1 year. What happens after the arbitral award is pronounced? The real trouble starts after the award is made, because that award is going to get challenged in a court by the losing party. And once it gets into the legal mill, then it languishes, it festers, it goes on and on endlessly in the courts. Therefore, the legal framework which will ensure that that prolongation in the courts also is addressed and reduced is something that needs to be addressed. I'm sure some recommendations in regard to a possible amendment, some possible amendment to the statutory provisions that are today holding the field may come up. Sensitizing arbitrators and courts about the need to expedite and unburden the process by showing deference to arbitral adjudications is another area. There has been over the past 2 days a very predominant opinion here among participants that courts in India interfere unduly with arbitral awards. Now that criticism is not misplaced, and I personally hold the view that once an award is made and it is challenged in the court, the first question that the judge asks is, who was the arbitrator? Because the judge wants to know whether the award is honest. There have been cases where even judges have faltered, but there is a general impression, and I think that's a well-founded impression, that when it comes to a judge working as an arbitrator, the courts will presume that the arbitral award may suffer from any error as such, but will not have any vitiating circumstance or element of having been corrupted by any extraneous consideration. And therefore, I think we need to sensitize courts about the need for showing deference towards arbitral awards, subject, of course, to the grounds on which such awards can be challenged if there is a challenge. But I feel the judicial sensitization about the need for maintaining awards rather than setting them aside is also a very, very important aspect which needs to be addressed. They say that the real trouble of a decree holder starts after the decree. And this is true even in the case of people who get an award in their favor. His real problem starts at the stage of execution of that award. And we have provisions in the Indian Act which say as to when can you refuse to execute an award or recognize an award. And it is a paradise for a lawyer to interpret the provision and drag on the process of execution of the award endlessly. I think these are areas that need to be addressed, and that is where I think we are lagging behind. Other jurisdictions, and I particularly mentioned Singapore. Maybe there's a participant here, Justice Patrick from France, also told us how efficient the system of execution of the awards in those countries are. And I feel that we need to not only train judges, but also have a relook at the statutory provisions which govern arbitration in this country. Having said that, I take the last 1 minute from the valuable time that you have assigned to me, and that is that this conference need not be just a flash in the pan. This conference has come after 70 years of independence, after 100 years of arbitration law in this country. This conference has brought such brilliant minds from all over the world, such brilliant minds who have such deep knowledge about how arbitration works in other countries and how efficiently it works. I think this conference needs to be followed up by taking some concrete steps. I am conscious of the fact that this has not been possible for this conference to evolve a consensus on various issues that have arisen for consideration that have been debated over the last 2 days. But I am sure an expert body, some outstanding people who have been associated with these deliberations and who have watched the proceedings will sit together and evolve the bare minimum that we need to do. And those bare minimum recommendations, I think, ought to reach the concerned quarters, whether it is the legislature, the parliament, or for that matter the government which is going to lead from the front in bringing about reforms. And so long as that happens, I think this conference would be deemed to have been well worth the trouble and well worth the time that you people have devoted to it. Thank you very much, and God bless you all.
May I now request our chief guest, the Honourable Prime Minister of India, Mr. Narendra Modi, to please share his thoughts with us.
Chief Justice of India, Justice T.S. Thakur, Honorable Judges of the Supreme Court and of the High Courts, distinguished guests and friends, ladies and gentlemen, let me begin by congratulating Niti Aayog for organizing this global conference. Perhaps the simplest definition of arbitration comes from Mahatma Gandhi, who said, "I had learned the true practice of law. I had learned to find out the better side of human nature and to enter man's heart. I realized that the true function of a lawyer is to unite the parties involved in a dispute. The lesson was so indelibly burnt into me that the last part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private company compromises of hundreds of cases. I lost nothing thereby, not even money, and certainly not my soul. Friends, India is today the fastest growing major economy and one of the most attractive destinations for FDI. Indeed, we stand out as a bright spot in the global economy. This is the result of India's fundamental strengths: democracy, demographic dividend, and demand. We need to fully harness these strengths. This can happen only if businesses make long-term investment that create jobs and sustain economic growth. Our domestic market has been fragmented. Different taxes across different states have made goods and services more expensive. This has hampered growth in interstate commerce. We are enacting a goods and service tax law to create an integrated national market. This will further boost domestic demand, create more opportunities for Indian business, and drive job creation. India is experiencing a digital revolution. This is bridging the digital and economic divide in Indian society in general and rural society in particular. A boost to the rural economy through this revolution will make the Indian economy even more robust. Innovative business models and app-based startups have instilled a spirit of enterprise among Indians. Yesterday's job seekers are becoming today's job creators. The legal profession is also opening up to the promises of the digital world. From cause list to case laws, the lawyer's library is now just a click away on your mobile phone. Friends, businesses seek assurance of the prevalence of rule of law in the Indian market. They need to be assured that the rules of the game will not be changed overnight in arbitrary fashion, and that commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant arbitration culture is essential. Toward this end, we have initiated far-reaching legal reforms. Over 1,000 archaic laws have been scrapped. We have enacted a comprehensive Insolvency and Bankruptcy Code 2016, implemented the National Company Law Tribunals, established a statutory monetary policy committee, and effected a merger of the commodities and securities market. Further, in harmony with Bankruptcy Code, we have amended the SARFAESI and DRT Acts this year to suit the changing credit landscape and augment ease of doing business. However, legal reforms can deliver desired results only when there is an effective and efficient dispute resolution mechanism. The independence of the judiciary is a basic feature of Indian Constitution. Common citizens as well as business repose immense faith in the integrity of the judicial process. Our government has taken various initiatives to improve the judicial infrastructure and administration. We have enacted the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015 for speedy resolution of commercial disputes. A national judicial data grid has been set up to provide data on cases pending in district courts across the country. Steps are being taken under the e-court mission to computerize the entire court systems. Our government has been working on a strategy for convergence of existing tribunals. This will help transform the existing complicated tribunal system into a simpler structure. We need to simultaneously facilitate a vibrant ecosystem for alternate dispute resolution, including arbitration, mediation, and conciliation. This will provide additional comfort to investors and businesses. More importantly, it will also ease the case load on Indian courts. Resolution of disputes through arbitration is not new to us. In ancient India, there were several mechanisms for settlement of disputes between the parties. These included the Kulani, our village council, Sreni, our corporation, and Puga, or assembly. Likewise, commercial matters were decided by Mahajans and chambers. Today, corporates and financial institutions want legal experts who can help close business deals and transactions without any dispute and litigations. If a dispute arises, corporates want to resolve them quickly through arbitration without going to courts. For this, they require specialized arbitration lawyers. Alternative dispute resolution processes also preserve personal and business relationships that might otherwise be damaged by the adversely process. Recent trends indicate that Asian centers like Hong Kong and Singapore have emerged as preferred arbitration destinations. As popular business hubs, they also rank high in the levels of ease of doing business. Thus, availability of quality arbitration mechanism is an integral component of ease of doing business to which our government is committed. Friends, creation of a vibrant ecosystem for institutional arbitration is one of the foremost priorities of our government. Recently, major amendments have been made to the Arbitration and Conciliation Act. This has made the arbitration process easy, timely, and hassle-free. Our law is based on the UN CITAL model law. The objective is to ensure that in normal circumstances, arbitral tribunal makes it towards within 12 months. In case of fast-track procedure, such award can be given in 6 months. Even the appointment of the arbitrator has to be decided by the court within a period of 60 days. The impediments encountered earlier in the grant and process of award have been removed. Further, as per the new law, any application challenging the award is to be disposed of by the court within 1 year. The enforcement of award can be refused by the courts only as per the international practices. These amendments have brought our arbitration process in tune with global best practices. This has given us an opportunity to emerge as a leading arbitration jurisdiction. However, great opportunities poses great challenges. These challenges include availability of excellent quality and globally recognized arbitrators, observance of professional conduct, ensuring neutrality and timely completion of proceedings, and cost-effective arbitration proceedings. Friends, India has no dearth of brilliant lawyers and judges. India also has a large number of retired judges, engineers, and scientists who can function as competent arbitrators in various fields. India's economic interests shall be better served by a higher number of arbitration experts and lawyers. This in turn requires widening the ambit of legal education in India. There is need to develop specialized arbitration, bar associations. We also need professionally ruled arbitral institutions which can deliver international standards of services at reasonable cost businesses in India. We welcome internationally recognized institutions in this effort. We must deliberate on ways and means to supplement the efforts of the judiciary and arbitration mechanism. Mediation is one such mechanism, the potential of which had not been utilized much in the country. Friends, an enabling alternate dispute resolution ecosystem is a national priority for India. We need to promote India globally as an arbitration hub. As Roscoe Pound famously remarked, the law must be stable, but it must not stand still. We need to take inspiration from beyond our shores. This conference has provided the ideal platform to deliberate upon the crucial regulatory policy and mindset reforms on this. I'm sure the deliberations here shall help in further strengthening arbitration in India and set a milestone in positioning India as a global hub for arbitration among international practitioners, corporate houses, and the legal fraternity. We look forward to effectively implementing your recommendations. Thank you. Thank you very much.
Finally, in conclusion, may I call upon the Honourable Judge, Delhi High Court and Chairman Organising Committee of the conference, Honourable Mr. Justice Manmohan, to propose the vote of thanks.
Good afternoon. That was Prime Minister Narendra Modi delivering the valedictory address at the first ever global conference on strengthening arbitration and enforcement in India. In the beginning of his address, he said that he understands and he derives his understanding of arbitration from Mahatma Gandhi, who himself was a renowned barrister. He said that Gandhiji said that the role of lawyer and law should be to unite two parties who are in dispute. He also talked about how India is experiencing a digital revolution and how the legal profession is also opening up to this digital revolution. He referred to e-courts, where computerization of a lot of information and processes is going to take place. Meanwhile, he also referred to the need for a robust legal structure, and in that regard, he said that the government has scrapped a number of laws that are outdated, and he also spoke about the establishment of commercial courts to resolve disputes in the commercial setups. He spoke about how ease of doing business is very closely related to efficient arbitration, and that makes the need for efficient arbitration very important for any country, especially India, which is one of the fastest large economies that is growing. And he spoke about how easy, timely, and hassle-free arbitration is the priority of his government, and they've been working in this regard. And all of his address was directed towards making sure that India emerges as a global hub for international arbitration. So those were the highlights of Prime Minister Narendra Modi's address.